Good evening, dear ladies and gentlemen. I'm happy to welcome you at our third meeting already. Today we have an exciting topic, exciting speaker. This is Mario Tenore, who I know for quite a while, 15 years for sure. Mario is a very well-known expert on the topic of taxation of sports persons and artists. And Mario is of counsel of Pirola Pinuto Zai and Associati in Milano, beautiful city. So just feel free to drop by if you'll be there. And Mario did PhD on international taxation. Mario is also graduate from International European Tax Law in Leiden University. And Mario is pretty well known in professional world of international tax for being expert and being active in academic field and also in the field of practical work, taxation of artists and sports persons. So Mario, this was a rather long introduction.
Too long.
Please, floor is yours. So tell us what we should know about this subject.
Okay, thank you, Rustam, for this kind invitation, which I was immediately glad to accept because of my relationship with you and needless to say with the Leiden alumni and therefore, you know, initiatives that come from there are very welcome, given that I was a student now more than 10 years ago. Unfortunately, it was 2006, 2004, 2005. So, but still, I cherish very nice memories about that period. So, the topic for my intervention is Article 17, OECD Model Tax Convention. It's a rather niche topic. We shall focus only on one article of the OECD Model Tax Convention. We shall, of course, try to address what I believe are the most challenging issues arising from the application of this article of the model. I will use a PowerPoint presentation. Hopefully, I shall be able to share the screen, which is always a challenge. Let's see. Share. Yeah. Well, by now you should be able to see the screen. Now I will. Can you confirm, Rustam?
Yes,
that,
yes.
The screen appears. Well, we shall try to keep the discussion not that long. It would be nice to have a final round of questions from the participants. I will leave, as agreed with Rustam, 15 minutes for the questions at the end. Needless to say that if there are questions during the intervention, I mean, I can also reply or try to reply to the questions. But in any event, there will be enough room for an interaction with me for those who want, of course, interact and raise questions on this specific topic. Article 17 is a rather simple treaty provision. It consists of two paragraphs, paragraph 1 and paragraph 2. We will address rather in details the pillars which are underlying the provision in the next slide. For the time being, I would like to draw your attention on the fact that, as you may read from the first 6 words of paragraph 1, this is a special provision vis-a-vis Article 15. So Article 17 applies ratione materiae, so due to the specific nature of the income concerned to activities carried out by entertainers and sport persons, even if those activities are carried out within an employed status. So Article 17 prevails over Article 15. This is rather clear from the wording of the provision. There is no specific derogation to Article 7. So that does not mean, of course, that entertaining activities carried out under a self-employed status are not caught by Article 17. Article 17 still applies and prevails over Article 7. There was no need to include the specific carve-out for those activities in Article 15 because we all know that Article 7, paragraph 4 provides for other articles of the treaty which deal with specific item of income like Article 17. Those articles prevail, take precedence over Article 7. So now, having said that, what are the pillars underlying Article 17? Well, first of all, Article 17 places a decisive role on the place of the activity. If we look at Article 17, paragraph 1, Article 17, paragraph 1 makes it clear that income derived by an entertainer or a sports person from that resident's personal activities as such exercised in the other contracting states may be taxed in that other state. So what is decisive is the fact that an activity is carried out physically on the territory of the other contracting state. And if so, the income that derives from that activity may be taxed in the states where the activity is performed. It goes without saying that as the provision puts, as we saw, a fundamental relevance to the place of the activity, the provision itself applies to activities which have a predominantly a performing nature. So this is clear from the commentary. In order for Article 17 to apply, there must be a physical performance carried out in the territory of the other contracting state. So in the states other than the states of residence of the entertainer. Article 17, as we said, requires an activity, but this is not enough. The activity must be of an entertaining character. And this, we shall see, is defined in the commentary. It's to some extent also clarified in Article 17 itself, which makes reference to a list although not an exhaustive list, but makes reference to a list of persons that are deemed to carry out an activity with an entertaining character. Article 17 indeed makes reference to, as we see here, entertainer of performing in theaters, in movies, in radios, performing on television, or sports persons. Whether or not the performance is carried out in public is not a relevant feature for the application of Article 17. And this is rather clear if we look at the example of an actor playing a given role in a movie. So clearly the activity as such, which is being performed by the actor, is an activity which is covered by Article 17. Whether the activity is not carried out in front of a public, because the production of the movie clearly anticipates the publishing of the movie, and so when the movie will be when the movie production will be over, the movie will be displayed in cinemas, for example, on TV. Well, the fact that the activity was performed by the actor for the movie production, not in front of a public, that of course doesn't affect the application of Article 17, which still applies to the fee or the remuneration that the actor earned for the movie production, for playing a role in the movie production. An important feature of Article 17, which adds on top of those which I just mentioned, is that the provision does not require a minimum threshold as far as the duration of the activity or presence in the other contracting states is concerned. This is clearly an important, maybe the most relevant feature of the provision, which allows activities of very short duration to be taxed in the states where the performance is held. And this is a distinctive feature of Article 17 vis-a-vis other treaty provisions, such as Article 15, for example, if not mentioning Article 7 of the OECD Model Tax Convention that allows profits to be taxed in the other contracting states insofar as those profits are attributable to a permanent establishment located in the other contracting states. Last but not least, the provision applies to income which is derived by the entertainer or sports person in connection with the entertaining performance or in connection with the sport performance. But as the commentary clarifies, and we will later on discuss this feature more in detail, Article 17 also applies to income which is closely connected to the performance. So not income related to the performance as such, but income which is closely connected to the performance. And we will later on better, let's say, illustrate the concept of closely connected income when we will discuss taxation of, for example, image rights or taxation of merchandising income. Those are forms of income which are regarded under certain conditions, of course, and we will see later on what are the conditions, as income which is closely connected with a given performance. So that means that Article 17 will also apply to these items of income, insofar as, again, these items of income are closely connected with the performance. So clearly, I mean, this is a general overview of the provision. As we said, the place of activity is the pillar on which the entire Article 17 relies upon. As you can see, there is no reference to a minimum duration, no reference to the residence of the payor of the income that might be resident in the state where the performance is held or elsewhere that doesn't play a role in the allocation of profits under Article 17. As we mentioned, Article 17 contains a list which is not exhaustive of persons that are considered to be entertainers or sports persons. Article 17, as we said, includes stage performance, film or film actors or actors in general. And the commentary also refers to other, let's say, cases where a person may be regarded as performing an activity with an entertaining character that must always be present for the application of Article 17. And the same goes for the list of sports persons, which is broadened in the commentary to Article 15. The commentary to 17. The commentary to Article 17 also refers to the term sports person as including those which are not involved in the carrying out of traditional athletic events, so runners, jumpers, or swimmers. But the term also covers, let's say, persons that are deemed to carry out the sport activity for the purpose of Article 17, like snookers, for example, or players of billiards or chess and bridge tournaments and so on and so on. It is not always easy from a practical standpoint to draw a distinction between persons that qualify as entertainers or sports persons and persons who do not qualify in their activity as such. The commentary, as I said, provides for some clarity. However, the commentary, in my view, is not always, let's say, so clear in defining when an activity of an entertaining character is performed. We had in Italy a long-standing, I would say, discussion, for example, on whether fashion models qualify as entertainers. That was the predominant view of the Italian tax authorities that were considering models performing in Italy during fashion shows held on the Italian territory as being performing an activity of an entertaining character, and so being covered by Article 17 of course, with regard to the activities that models perform on the Italian territory. The commentary has been modified to clarify that models are not in the scope of Article 17. Not surprisingly, the Italian Supreme Court in 2018 rendered the judgment, I would say a landmark one, that put an end to this discussion as to whether fashion models are within the scope of Article 17. And the Italian Supreme Court, our Corte di Cassazione, decided that models are not in the scope of Article 17 because the activities which are performed by fashion model is not an activity which has a predominantly entertaining character, because models perform during fashion shows, and the very purpose of fashion shows is to stimulate buyers to place orders of clothes which are shown during the fashion show. So the main, let's say, objective of the event itself, of the fashion show, is not that of entertaining the public, but that of convincing the buyers to place as more orders as possible of clothes. So this was the final position in the judgment of our Supreme Court. Actually, the Supreme Court in the judgment, which is unfortunately not available in English, leaves open, however, the possibility that models could qualify as entertainers under Article 17. This, however, is a case-by-case analysis that must be conducted as to whether models, they act as such in the framework of the fashion show, or whether they do something more than working on stage to present clothes during the event. Clearly, I mean, this opens the floor for a discussion that might turn to be endless, because, well, then one could say, okay, but if a worldwide famous model attends the show and works on the stage, clearly there is something more than a mere presentation of clothes during the events. The fact that a worldwide famous model is invited to work on the stage clearly has also the purpose of attracting, and the purpose of entertaining the attendants to the fashion show. Whereas if a model that is not worldwide known is called upon by I don't know, a fashion brand to work on stage, there is only let's say the purpose of presenting the clothes during the event. So how to do the borderline is not always easy in practice. Moving forward, preparation, rehearsals, and training fall within the scope of activities of the entertainers and sportspersons for the purpose of Article 17. So as much as the performing activities also those activities which are of preparatory nature, if we may say so, might give rise to taxable income in the states where those activities are performed, even if no public performance takes place. But we have already said this is not a decisive element for the purpose of applying Article 17. There has been an interesting ruling by the Italian tax authorities that has been rendered in 2020, so a rather recent ruling published by the Italian tax authorities that entailed with the following situation. There were two musicians that were not Italian tax residents and that were under a contract with an Italian foundation entitled to receive a remuneration in connection with the participation to the concerts. It was agreed that no remuneration was due in case of cancellation of the concerts that might occur due to force majeure, for example, during the COVID pandemic. Those clauses might well appear in contracts like the one that was analyzed by the Italian tax authorities. According to the contract, all preparatory activities, including concert rehearsals, had to be carried in Italy, and such activities had to be carried in Italy subject to the guidelines provided by the contractor, the Italian foundation. Interestingly, and this was rather, I would say, unusual in the sense that based on my experience does not correspond to market practice, no remuneration and no reimbursement of related expenses would have been, let's say, agreed between the parties, the musicians and the Italian foundation, in respect of the rehearsals, so in respect of the preparatory activities. So under the contract, the musicians were entitled to receive remuneration, but the remuneration was only for the carrying out the artistic performance, and the concerts were supposed to be held outside of the Italian territory. So the question was whether in such a case, the remuneration paid by the Italian foundation for the concerts held outside the Italian territory was subject to Italian tax. Italian domestic law entails a 30% withholding tax for activities performed in Italy by non-resident persons who have a self-employed status. Interestingly, the Italian tax authorities concluded that the remuneration paid to the musician was not taxable in Italy, even if the entire preparatory activities were performed on the Italian territory. So the conclusion was that, according to the Italian tax authorities, there was no remuneration for the concerts activities. The remuneration in the contract was only for the carrying out of the concerts outside the territory of Italy. There was no remuneration for the rehearsals under the contract, rehearsals were not specifically remunerated. And so given that the performance took place outside the Italian territory, the income paid by the Italian foundation was not subject to Italian tax under Article 17. So it's, I think, a rather interesting position taken by the Italian tax authorities. In my view, the conclusion is biased by the specific clause that was included in the contracts, according to which the entire remuneration had to be referred to the participation to the concerts, and that no remuneration was, to some extent, due in case of cancellation of the concerts, and that no was related to the rehearsals activities that were carried out by the musicians on the Italian territory. Now we can move forward with other, I think, issues that may arise from the application of Article 17. So as we said, Article 17 places a decisive role to the place where the activities are performed. And as we said, there is no minimum duration entailed in Article 17 for the activities. And in addition, Article 17 does not place whatsoever relevance to the place of residence of the payor. So an issue that might arise is that when a performance is carried out in various jurisdictions, separate tax liabilities may arise in the states where the performances are held under Article 17. Clearly, assuming that the states of the performances under domestic law do tax a performance regardless of the duration or the length of the performance. So, for example, in Italy, we do have under our domestic law a provision that simply says that for self-employed activities, for example, the same goes for employed activities. The fact that the activity is carried out in Italy clearly determines the territoriality, and so the income derived therefrom is regarded as sourced in Italy, regardless of whether the activity has been, performed for a long time or for a short time. It really doesn't matter. What matters is whether the activity has been performed on the Italian territory. As I said, when the performance is held in various states, there is an issue that is first whether the states of the performance do tax the performance. If so, there is an additional issue, is how to allocate the income to the various states where the performance is held. Because you may have clearly the case of, well, I make reference in the slide to Formula One drivers. You may have the case of Formula One driver that wins a race in a given country and receives a bonus, and that in that in this case, there is no issue whatsoever of how to allocate the income between the various jurisdictions, because the bonus is received in respect of the winning of a given race in a given jurisdiction. But the issue may arise when you have under a contract, for example, a contract with the theme, a remuneration which covers the entire year. And so you need to find an allocation key, okay, to determine how much of the income is allocable to the various jurisdictions. You need to do that for two reasons, at least. One is to determine the taxable basis in the state of the performance on which the state of the performance shall levy its domestic withholding tax or tax. And on the other end, you need also to find an allocation key to determine, for the purpose of the resident states, how much credit you would give under our tax credit mechanism. So you have several issues in practice of allocation of the income. And of course, you have additional issues in terms of procedural obligations, because as I said, you may well have the case in which the payer is Italian, the performance is held in, let's say, Japan, and the sports person is resident, I don't know, in France. Okay, so in that case, the issue is how to pay the tax in Japan, because under Japanese law, for example, Japan applies a withholding tax to the portion of income which is derived by Formula One drivers for the participation of races held on Japan, so on the Japanese territory. So the question is, how do I concretely comply with the tax liabilities arising in Japan? Very often, the team appoints a fiscal representative that levies the withholding on behalf of the team. And so this is practically the way the tax is paid to the Japanese states. But you may imagine how complex this situation might end up at the end when, for example, if we look at Formula One drivers, you have, I believe, 23 races, maybe in 20 different jurisdictions, and so potentially 20 separate tax liabilities, although as a matter of fact, as far as I know, there are only 9 or 10 states that levies a tax on the activities carried out due to the participation to races in the respective on the respective territories. So the issue is how to allocate the income, and clearly you may use different criteria that might, in theory, all be valid. One is the number of races. A different criterion might be the number of days spent in a given jurisdiction. These are, anyway, all issues that I'm sure that Case would be happy when I make this statement. Do not deal with the allocation of taxing rights, which is for Article 17 to decide, but deals with the concrete exercise of the taxing rights allocated under the tax treaty, it's Article 17 specifically. And so it's a matter for domestic law to decide how to and which allocation key one should use. Although clearly a mismatch, the use of different allocation keys might raise issues of double taxation. So I see that there are 5 maybe questions. Am I right or not?
Some of them, they are not really questions, they are statements, or let's say signs of appreciation.
Okay.
You personally should be taxed as an artist because you're very entertaining.
Yes, well, actually there is in the commentary some reference to conference speakers. So and for example, the commentary paragraph 3 says that Article 17 does not extend to a visiting conference speaker. So, but the question is always the same: how to draw the borderline between a conference speaker who is entertaining and a conference speaker who is not, because as we said earlier, also in the case of fashion models, which are in principle outside the scope of Article 17, our Supreme Court said, but you must look at each single case, whether the participation to the show at the end, let's say, brings about some entertainment for the attendance to the fashion show. So, I mean, it's a gray area, definitely, the one of defining entertaining activities, and is very, of course, subjective. So if there are no questions, as I understand from you, Rustam, then I would move forward. In any event, I must say that I don't know if the lecture is entertaining to you, but I'm having fun to spend time with Rustam and you on this topic. So for me, it's entertaining. Special categories of payment. So as we said earlier, Article 17 applies to income, which is the remuneration of the performance, but not only. Article 17 also applies to income which is closely connected to the performance. So strictly speaking, this is not the remuneration of the performance, but it's an item of income which is derived by the entertainer as a consequence, as we will see later, of the performance. So the commentary tries to illustrate this vague concept of close connection, and it does so in particular with some categories of payments, which I refer as special categories of payments, namely with regard to sponsoring and advertising, and with regard to image rights, which are dealt with respectively in paragraph 9 and paragraph 9.5 of the OECD model tax, of the OECD commentary to the model tax convention. Yeah, maybe we could go to the core of the commentary here. So the commentary, as I said, makes an effort to define the concept of close connection. Commentary says in paragraph 9, third period, as a general rule, a close connection can be found to exist where it cannot be reasonably be considered that the income would have been derived in the absence of the performance of these activities. So this is the test to be conducted, whether the income would have been derived if the main performance would not have taken place. And the commentary also provides some additional clarity to the definition of close connection. For example, paragraph 9, again, fourth period, the commentary provides for some examples of closely connected items of income. So, for example, the commentary refers to the timing of the income generating event. For example, when, in this case, a professional golfer renders an interview during the tournament in which she participates, although the remuneration for being interviewed is not remuneration for the main performance, still that remuneration would be taxed under Article 17. Why? Because there is a timing connection between the event, so the tournament, and the interview. The interview takes place during the participation of the golfer to the tournament. Another element which is emphasized by the commentary is the nature of the consideration for the payment of the income. And the commentary makes an example, the example of a payment made to a star or tennis player for the use of his picture on posters advertising a tournament in which he will participate. Here, we could maybe not use the timing connection. So the example we had addressed 1 minute ago. Why? Because the tournament does not, has not yet, if we look at the wording of the commentary, has not yet taken place, but will take place in future. And the star tennis player here will receive a consideration for his using his picture in advance of the tournament. So there is no timing connection, but the nature of the consideration, according to the commentary, is such that makes the income received for the using of the personal picture closely connected to the participation to the sports event, and therefore Article 17 also covers this additional remuneration. So this the income that the star tennis player receives in addition to the income that he or she might derive in connection with the participation to the tournament. And the commentary finally also places an emphasis on the contractual arrangements. So close connection may be evident from contractual arrangements. This, honestly speaking, is, in my view at least, to some extent debatable, because it seems to open the door to artificially decide, or at least to leave the parties to artificially decide when a certain item of income is connected to a performance or not. Do remember the case of the musicians that was addressed by the Italian ruling. I mean, in my view, the conclusion of the tax authorities was not wrong. The point is that you open the door to possible contract engineering, or artificial arrangements, or you open the floor to parties to include clauses, whereas which might impact on the application of Article 17 in this case. So it's a bit dangerous, at least, to leave to put some emphasis on the contractual arrangements. That's my personal opinion. So, as always, even here we have a gray area in the middle between obligations that are clearly connected with a given performance, like using a specific equipment or wearing a specific clothing during the performance. No one would doubt, I believe, that there is a close connection between the income which is paid to the performer by the sponsor and the main artistic or sports performance. So the income would be covered under Article 17. On the other hand, at the very opposite side, we have cases where an income is paid, for example, for the use of personal image of the artist or the sports person. I use the expression, these are off-course activities, meaning that the sponsor may use the image of the sports person not necessarily in connection with the carrying out of a sport activity or of an entertaining activity by the sponsoree, by the entertainer or sports person. Or let's say, for example, if a Swiss brand that manufactures watches, you may want to think one you like. There are many in Switzerland, but sponsors, let's say me, Mario Tenore. Let's say I am a famous football player. To wear a specific watch in my time outside my sport or artistic activities, or let's say the sponsor pays the artist or the sports person to use the personal image to advertise products on a newspaper or on television. There is clearly not a connection with the sports or the artistic activity. And so in that case, we miss the close connection requirement, which is fundamental for the application of Article 17 to these streams of sponsoring payments. So I have try to provide some examples to illustrate when Article 17 applies, when it does not apply. Clearly, there are several cases where Article 17 applies, but I list only one, but we may think about more. One case, for example, promotional activities not connected with the sport events, and the sports person is called upon a sponsor to intervene in a commercial television to I don't know, promote a given product. Well, that should not be Article 17 activity, but I say should not be, because even there, the question is always whether the participation of the sports person to the television commercial is somehow an activity with an entertaining character. So it's always, let's say, a relative concept we are faced with, because it's true that the main goal of a promotional spot which appears on television is to sell products, is to sell the advertised products. But on the other hand, there are several television commercials which are also entertaining. So just not passing a commercial message to the audience, but trying to entertain the audience at the same time. In Italy, I mean, we may see that there are some Italian colleagues who are attending. We may call upon several examples of television commercials which at least make an attempt to be entertaining, because I mean, at least for me, television commercials are always boring when they appear in the very middle of a movie, and so you are always somehow disturbed and never entertained by the television commercial. But then there may be some television commercials that could end up being entertaining. And this is again one of the confusing and I would say really critical points in the application of Article 17. So what is entertaining and what is not? And actually, if we look at the commentary here makes a reference to the case of a former sports person, which might always be the case. In Italy, we had former, and we still have a lot of television commercials which involve former sports persons that indeed participates to a television commercial. And the commentary says that a former sports person participating to a television commercial might be covered by Article 17. I think this is a very, very confusing example that brings the confusion at the highest level, because, I mean, if a former sports person might be regarded as an entertainer when he or she participates to a television commercial, that is by definition the television commercial something which has a main commercial goal and not something which has the goal of entertaining the audience. The goal of a television commercial is selling the products which is advertised. And so when the commentary refers to a former sports person that participates to a television commercial as an entertainer, so includes the former sports person in the list of those that might be regarded as entertainers, I think this is confusing. Because remember the case of fashion models. The model says, the commentary says that model performing as such should not be regarded as entertainers. This is paragraph 3, 6. So why a former sports person participating to a commercial should be covered by the definition of entertainer, whereas the model that participates in a fashion show, which has also a commercial purpose, does not qualify as an entertainer. Where is the borderline? This is a really big question that is arising from the reading of the comment. Where is the borderline between the two examples? So it's not the fact that I participate to an event with a commercial purpose, such as a fashion show or a television commercial, that takes me outside of Article 17, but it's my role in the event which is decisive to decide whether Article 17 applies or does not apply. So I can be entertaining in a television commercial and be covered by Article 17, even if a television commercial is something different from a tennis tournament or something different from a football match. We are approaching the European Championship, so I'm sure that many of you are really getting anxious about this tournament, like I like football. So it's not really the type of event which is decisive, but it's the function, the role that is performed by the person in the event, which to me should be decisive. And this is something that the commentary does not really clarify in a neat, at least, way. But this is something you may draw from the, examples which the commentary makes here and there that might be a common principle, but this is not something which is clearly, let's say, emphasized or pointed out in the commentary to Article 17. So I don't know if we want to, are there any questions? Yeah, maybe Rustam, what we can do, it's 7 o'clock, so we have spoken for 1 hour. I see that there are a number of questions, if I'm not wrong. Maybe it's time to reply to the questions.
Well, it is up to you, Mario. If you find it find it right time to go through the questions, but please keep in mind that you don't really have to answer all of them. Some of them, to my opinion, do not really straightforward relate to your presentation. We can just skip them. Not out of disrespect, but just, well, guys, just be reasonable. Because we're just halfway. So feel free to pick up the questions. Which
yeah, but you know, it's never polite not answering to the question. At least I try to answer the question. So let's now maybe go few minutes more on the slides, and we will then let's say we will then try to respond to the question. Maybe what we can make a quick reference to well, other types of income which are regarded as closely connected. Well, the same reasoning goes for broadcasting, goes for merchandising income. For example, for merchandising income, this is quite interesting, because merchandising income is clearly a business activity, which by itself would not be covered by Article 17, but due to the fact that Article 17 applies to income that is closely connected, then if the merchandising business is carried out during the artistic performance, then the income itself, although not being a remuneration for the performance, will be attracted in Article 17. Well, as we said already, Article 17 does not deal with the exercise of the taxing rights. This is something that is dealt with domestic law of the member states, sorry, domestic law of the contracting states concerned. This is, well, quite normal, and it's obvious because, as we know from our lecture on fundamental rules held by Professor Barrat, I still remember, even if more than 10 years have already passed, but tax treaties allocate the taxing rights, and again, the exercise of the taxing rights and the timing of the exercise of the taxing rights is something dealt with by domestic law. And so you have a variety of domestic laws that you know, may tax the income related to the performance carried out on their territories, and you know, applying various mechanisms to exercise the taxing rights. In Italy, as I mentioned, we do have a 30% withholding tax, which is applied on the performance by foreign residents in Italy. Okay, so I think it's now time maybe to stop this let's say analysis of selected topics of Article 17. Maybe what I can do, I can have a look at the questions. I don't know if it is possible, Rustam, also for the participants to intervene
In principle, yes. In principle, they can just raise hand.
But in fact, nobody shows.
Well, but, I'm a bit hesitant about directly giving a person raising the hand floor.
Okay.
Sometimes they just press it. Actually, in 50%, they press it by mistake. And when okay, guys, sorry, I was just confused. So if you would like to join the discussion, just type this in the chat. So in chat section, you will be able to type, please let me in, and I will be happy to give you the floor. Okay, I have one hand raised, but I'm just feared that this might be my mistake. If you really would like to join the discussion and speak, just type something in chat. And wow, I do not. Fahid, if you would like to speak, please. I can put my question in the Q&A session. So far, I do not really have direct requests for speaking option. And when you would like to speak, when you have something to say, sure, let us know. Meanwhile, there is a number of questions. First of all, from my perspective, thanks a lot once more for excellent presentation, Mario. And I didn't really intervene because I was sitting quiet because there was no need in my involvement. You did excellent job, so I didn't have to support you. We can go to the questions.
Yes, so thanks, Rustam. So first question is, curious how Alexander Markov, which I warmly greet, curious how that works in practice in this more and more digitalized world. Also NFT artworks and related income, how these are treated locally and internationally. So NFT means, if I'm not wrong, non-fungible tokens, or am I right? So it's something connected with the payment. If I try to interpret the question, if, for example, I am paid for an artistic performance through cryptocurrencies or bitcoins, well, I don't know if this is the question, but in my practice, I have it already, a couple of, or even more, bunch of cases where sportspersons were paid not in money, but through virtual currencies. And so under Italian law, actually, it's to some extent something that is not different from the case in which you are paid in money, so with the real currency. Simply, the issue is how to convert the amount of NFT or bitcoins, whatever cryptocurrencies, at the time you are paid in euros, and then apply the same rules as if the consideration was directly paid in the real currency. So that does not really affect the application of Article 17, but only, again, it's an issue of determining the amount of the consideration in euro. Niels says, which I also warmly greet, various interesting lecture might also be considered as entertainment. I don't know, but I take it as a compliment.
Yeah, it is a compliment.
Well, you could also take it the other way around. This is something that is purely outside, any scientific yardstick. So it's entertaining and not, having a didactic or, displaying its really scientific function. Then there is a question, well, which is raised in two different languages. I only read income taxation as to place of rendering services. That does it cover all taxes and countries? Well, it covers clearly the taxes which are covered by the specific tax treaty and the countries which are parties to the specific tax treaty. So clearly what we said is we spoke about Article 17 of the OECD model that we know is replicated in many existing treaties. Italian treaties, most all of them, for example, contain an Article 17.
Okay. Well, luckily, I can help with reading the first part, the Russian version of it. Taxation at the place of rendering services. Well, I presume I'm kind of interpreting question. Is this the main principle for all taxes in countries? That's actually an interesting question. So, taxation at source, is this worldwide principle of taxation?
Okay, so then
sorry for interruption. My response would be that, well, the short answer is yes, but there could be lots of exceptions. But again, well, I recall my time in Leiden, and even being very focused on very narrow subject with different backgrounds, we had such a different experience. For me, something was so exotic, but for guys from Latin America, it was just basic principle of fundamental tax principle. So for Russian attendance of this lecture, taxation at source is basically the general principle. And I believe this is reflected one way or another in this question. But there might be different views, might be different experience in other countries.
Yeah. Then we have another question from I don't know if it's a lady or a man that says, do relating expenses follow the same taxation as the services rendered? Well, very simple. It's a matter which is dealt with domestic law. So, as I said, Article 17 is a distributive rules, and as such, it only plays the function of allocating taxing rights. The exercise of the taxing rights is left to domestic law, the contracting states concerned. And clearly, when I say the exercise, I also refer to issues like what items of expenses are deductible, whether expenses are deductible in full or partly. And so all these questions are domestic law issues not dealt with in Article 17. I don't know if Rustam, in Russia, there are specific rules. In Italy, for example, taxation applies, as I said, with a 30% withholding tax, which is applied on the gross amount of the income that is attributable to the Italian performance. So there is not even an issue of allocating expenses to the income. There was some opening by the Italian tax authorities, well, in some old rulings, whereas it seemed that a non-resident that might want to deduct expenses related to the Italian performance might do so, but it could do so only upon filing of a tax return. And so the application of a 30% withholding tax is justified as let's say, method of taxation which avoids further complexities for the non-resident person when it comes to the filing of the tax return. So otherwise, the non-resident should file a tax return to claim deduction of expenses connected to the performance. I don't know Rustam, what is your view in your jurisdiction if you have a withholding tax or different methods of taxation?
Well, in Russia, the general principle is also 30% withholding tax on gross amount of payments. This is a general tax rate applicable to income of non-resident individuals from Russian sources. I'm not really very much into taxation of sports persons and artists, but I do not recall any specific rules on this subject either. So hypothetically, if someone wants to claim expenses, they would just structure the deal differently. They will just attribute the income to a particular company, and then they might deal with this matter more efficiently.
Yeah.
Good. Then we have a question from Kempe, which I also know and I also warmly read. He says, how is the interaction between the anagrafe tributaria, well, that's a domestic law, Italian domestic law issue, and the traveling musician that may do a tour of max 2 months in the country? Well, clearly there is no interaction campaign in this respect, because the 183 days rule is a rule that is one of the criteria that are applicable in Italy to assess the tax residence of individuals. But if a musician comes to Italy for a short period of time, obviously that does not even raise the issue of whether the musician could qualify as Italian tax resident. And 2 months is indeed not a qualifying period of time for tax resident purposes. And then second question, same for sports person who arrives in Italy to start to play for a new club in Italy on August 1st of a year. Well, if the football player, which I believe is the case you referred to, that comes to Italy in August, does not qualify in the year of arrival as Italian tax resident. As I said, if he spends less than 183 days on the Italian territory, he would still be regarded as a non-resident for the year in which he transfers, he moves to Italy. In Italy, we do not have the split year system such as in the UK. So either you qualify as a resident for the full tax period, which is the calendar year, or not. And if you arrive in the second half of the year, in that year, you are regarded as not being tax resident for Italian purposes. Then Niels again, so he says, if the activity itself is forbidden and eventually will not take place, the income derived from promotional activities could in theory still fall under the scope of Article 17. Actually, no, and this is again a confirmation that Article 17 places fundamental importance to the carrying out of an activity in the other contracting states, because in the commentary I should find the paragraph, but there is yes, I found it. There is in paragraph 9 reference to payments received in the event of the cancellation of a performance are also outside the scope of Article 17. So that means that in the absence of a performance, the contracting state, the other contracting states may not tax the cancellation fee. Precisely because of the absence of material activity carried out in the other contracting states. Last question from Linus, which I also very well know, and I greet him as well, as we have met in the past conferences speaking on Article 17, interesting Portuguese cases on image rights. I still remember. This is from Portugal. Dear Mario, given the ongoing debate about Article 17, do you support the position that this article should simply be removed from the OECD Model Convention, or what would be your suggestion to improve it? Thanks for your great presentation. Well, thanks for this, for the question, and for saying that you enjoyed it. Well, honestly speaking, I'm not in favor of the elimination of Article 17, because although, again, I believe that Article 17 does not solve all problems that may arise internationally when it comes to entertainers performing in various jurisdictions. As we said, there are fundamental issues which are not dealt with at all by Article 17, and allocation of income is one of those issues. I think having Article 17 clearly, at least, is to some extent something I consider positive. Although I know that the trend, as you're also mentioning, is in some jurisdiction not to have Article 17 in the OECD Model Convention, although I believe that when Article 17 was introduced, there were different concerns, because Article 17, as we said, applies to income from entertaining activities, even if the activity is of a very short duration in time. And so the concern at that time in 1963, when the provision appeared for the first time, the concern was that entertainers were resident in tax haven jurisdictions, so they were not paying taxes in the state of residence, and they were also escaping from tax in the states of the performances. Clearly now this is something that maybe it's a bit obsolete due to the improvements and developments in the exchange of information. Maybe we do not need Article 17 to let's say approach problems of tax evasion, but in any event, I think it's still a useful standard that I would not remove from application from the OECD Model Tax Convention. So in this respect, I agree with keeping it.
Okay.
Okay, well, I think there are maybe no more questions, right? Am I right or wrong?
No, I do not really see any further questions.
There are some comments, maybe.
Yeah, comments, but they do not relate. You're most welcome to comment on some of these points. But there is, what I see, the termination of double tax treaty between Russia and the Netherlands. That's not really the focus of today's meeting.
Okay.
I will be happy to comment some other time, maybe, but I don't want to keep Mario.
All right. So thanks a lot for this, and for again for the invitation and for the possibility to be in touch with so many colleagues all around the world.
Okay.
And of course, thank you, Ustama, for all the help in the preparation of this lecture. Thank you.
I'm basically just coordinating the willingness and openness of Leiden alumni to share the expertise like you did, Case introduce this. Next week, we are going to have another interesting session on US tax developments. Pretty hot topic, so everyone is curious what US is doing with international taxation, with all these scandals of how little tax was paid by the top wealthiest people of United States. Please feel free to drop some questions. I will pass them to the speaker in advance. Thank you once more, Mario, and thank you for participating. So see you in 1 week time then.
Thank you. Bye-bye.
Bye.